Okay, well, we are going to start today. So welcome, everyone, to our webinar, our fourth and last in this series, with uh, on Strata Rentals. This webinar is resolving complaints and conflict. Throughout this webinar, feel free to put your questions into the Q&A feature. We'll get to them after our prepared presentation that Wendy and I have put together. But don't wait until that part to get them in. As soon as you think of a question, go ahead and pop that in there so that when we get to the Q&A, we have a lot to go through and you don't forget. We'll try to get to as many questions as possible. We have a fair bit of time for Q&A today. The session will be recorded, so if you're coming into this partway through, or if you have to leave partway through, don't worry. We will send out a recording. It'll likely go out mid next week to all the attendees, and then also be up on our YouTube, both for us, and of course you'll get communications from VISOA on that as well. As mentioned, this session is the fourth in our series. You can see the first three on the LandlordBC and VISOA YouTube channels. So you'll have those, all of the previous videos are located there. And so yeah, let's get into the content of our webinar today. We'd like to take a moment to acknowledge the territories that we're in. Our offices are located in the Lekwungen Peoples territory, known today as the Songhees and Esquimalt nations. And we're grateful for the land that we are able to live, play, and work on. So just a brief introduction as to who we are. Today, as with throughout these series, we have Wendy Wall, president of VISOA. Wendy Wall has served on the Vancouver Island Strata Owners Association, or VISOA, board of directors since 2013, and as president since 2020. VISOA provides education, support, and advocacy for BC strata owners and strata corporations such as condominiums, townhomes, bare land, and commercial stratas. I'm Hunter Boucher. I'm Vice President of Operations here at LandlordBC. I have 15 years of experience in the rental housing industry with a focus on legislative issues and best practices. As an association, LandlordBC represents and advocates for all rental housing providers across the province. So the purpose of this webinar and our webinars in general is really to talk about the kind of the complexities that occur during residential tenancies in stratas. And we've gone over a lot of the basics of those complexities throughout the first three webinars. Now we're going to get into the conflict. So we're going to talk about resolving complaints and conflict. In this session, we are going to cover common types of conflict, what to do when you have a complaint, tips for writing a letter when letters need to be written to strata, for example, process for when council receives a complaint, paying fines, ending tenancy or eviction by a landlord or a strata, and of course, tips on how to prevent or reduce conflict. So I'll open it up now to Wendy. I believe you have our opening question, our opening part of the webinar.
Yeah, I just wondered from a landlord's point of view, what are the most common situations where their tenants or the landlord themselves are getting complaints, whether it's complaints from neighbors or complaints from a council?
Yeah, from our experience with our membership, um, uh, we generally find that the biggest type of complaint that landlords get when it comes to tenancies and stratas is around noise. Um, and certainly other issues such as smoking, pets, waste disposal is another big one, not properly sorting garbage and recycling and such. But the biggest one certainly is going to be noise issues. Um,
Yeah, I would agree with that too, because it's the same things that happen among owners as happen among tenants and owners. And you're right, noise, but to a lesser degree, every so often there's an issue with parking or the use of a recreation facility like a pool. But I agree, noise is the big one.
From my understanding, a lot of the issues that come up during a tenancy in a strata are really very much the same sorts of things that are going to happen in a purpose-built rental building, for example. So as mentioned already, noise complaints are pretty common in apartment buildings. Smoking is a fairly common issue in apartment buildings. Um, as you mentioned, parking, certainly that can be an issue. Though I think that, with parking becoming more and more kind of assigned parking with set stalls, I think it's a little bit harder to break those rules and a little less vague. So I think that's not as huge of an issue there, but certainly does come up. And then, of course, as you mentioned, the use of recreation or common areas is one that certainly can cause friction amongst tenants in a building, in a purpose-built building, and also, as you mentioned, between tenants and owners in a building. So, when we look at the strata environment, um, uh, you know, we have to take into account that we don't have a traditional landlord-tenant relationship only. We have council, we have other building owners, which are not governed or managed by the same owners, so they're independent. When a tenant gets when a tenant or an owner gets a complaint, what should they do about a neighbor when they get that type of complaint, if they were to have a complaint?
If they were to, yeah, I was thinking if they have a complaint, because it happens both ways.
Yeah.
And it's the same process. Um, Always a friendly chat, if possible, is a great way to find an early resolution. Some people aren't comfortable knocking on their neighbor's door or whatever, but of course you can't just stand there angry, ready to yell at somebody when they open their door. You have to come at it with a just having a conversation, not having confrontation. But one of the things that is big in stratas is, what is a complaint about? Because is it a complaint about something that is potentially a violation of a bylaw or rule? Or is it about something else that you're just not happy about? Because that's a really important defining feature. Your next step of what you do, which, if the problem isn't resolved, if you're the one who wants to make a complaint, there is no point writing to council if it's not something that's covered by the bylaws. Council can't do certain things. So, if you have a run-in with somebody in the lobby or something that's not covered by the bylaws, you can't rely on council to fix all the problems, because not all of them fall under their jurisdiction, so to speak. But if it does, and if it's something like noise or smoking, and if the bylaws address those things, then the tenant or the owner who's having the issue that they want to complain about, they can write a letter to the council, and also inform their landlord, because as you say, you've got this not even triangular relationship. It's almost like you have four different bodies, and keeping your landlord informed is a great idea. Some tenants I've found, and you may have found this too, they take all of their complaints to the landlord. That puts the landlord in a strange position because they didn't experience the noise. They don't know how loud it was. They can't speak firsthand to what the problem is. So sometimes it's inefficient to expect your landlord to make your complaint for you if you're a tenant. Or it happens with owners as well. There'll be noise and they'll say, well, why didn't my neighbor make the complaint? Well, come on, folks, you have to own the problem. And if it's bothering you that much, write the letter to council and start that process rolling, and don't wait 5 months until you're sleep deprived because the noise is driving you that crazy. let's just talk about noise for a quick second. This could be an entire webinar. But your neighbors don't always know what it sounds like in your suite. You know, like it sounds like they're dragging furniture. It sounds like they're throwing heavy things on the floor. Well, I can almost guarantee they're not doing that. They're doing something that's causing noise, and they might not even realize how loud that creates a noise in their next door neighbor, in their neighbor below. So it's really important for early resolution to make sure that the person who they think is making the noise becomes aware and has an opportunity to try to resolve it before everything escalates. And that's probably one of the biggest tips to come out of this webinar, is address it early. And I think you're on mute.
I tend to agree. Um, addressing early and having a conversation is, I think, key to trying to resolve these issues without it escalating. Within residential tenancies in general, within, purpose-built buildings, for example, apartment buildings, it's the same thing. Certainly, always informing the landlord is important, because ultimately, between a tenant and a landlord, the landlord is responsible for ensuring quiet enjoyment. That is under the act. That exists. That requirement is very, very firmly entrenched in the legislation.
And when you say
But
the act, just because we've got a strata, some
that's
strata
correct.
here,
The
you mean
Residential
the
Tenancy Act.
residential tenants? Okay.
Exactly. So within that piece of legislation, the Residential Tenancy Act, the obligation of a landlord is very clear. They must ensure that the tenant has access to live in their unit and free of unreasonable disturbance. With that being said, as you say, sometimes it's important, and not just sometimes, pretty much all the time, it's important that the tenant, you know, uh, try to tackle the issue as well. As you say, a friendly chat is important, and that's where introducing people to their neighbors is really helpful. Whenever I talk to landlords of strata units, when there is this sort of complaint, I will suggest. Well, if you know the owner of the unit, besides maybe the owner had the landlord had lived in the unit and they know the owner, they were neighbors. Introduce them, have them, come by the unit to do an inspection, see if the other person is willing to meet with them, and facilitate the beginning of that conversation if your tenant is not comfortable with that. Um, and when you have those open lines of communication, it means that people can, just maybe send a text message, for example, to their neighbor saying, hey, by the way, can you maybe turn the bass down on your stereo a little bit or something, whatever it might be. So you mentioned in here about the idea of writing a letter to council, both from a tenant potentially writing a letter to council, as well as an owner writing a letter to council. What should be in that letter? Are there any rules, any guidelines for these types of letters?
Absolutely. Yeah, so under the Strata Property Act, if you want to make a complaint that someone has allegedly broken a bylaw or a rule, the Strata Property Act requires that there be a certain amount of information in that letter. So, having a formal approach. Too often with with email being such an easy form of communication, or even texting, sending a one sentence saying, my neighbor is driving me crazy with their smoking, is completely unhelpful. You have to make it a little bit formal. You have to say, dear council, I'm writing to you because I believe that the owner, or if you know who it is, the owner or tenant of unit such and such is causing a lot of noise, and here are the dates and times and duration of that noise, excuse me, and what type of noise it was. So you might say, on March 3rd, there was vacuuming from 3 in the morning to 3:30 in the morning. There has to be some detail there. And the reason is that the Strata Property Act requires the council, when they notify the other person that there's been a complaint, They're not saying that the person broke a bylaw. They're saying we're notifying you that there's been a complaint. They have to give them what's called details of the complaint. So if you write an effective letter, the council can just take those details of what happened, paste it into the letter to the owner, and the owner or tenant who gets it is able to say, oh, that's right. I did vacuum really late at night that day and I probably shouldn't. But if you don't put enough detail in it, if you just say, oh, they were causing noise, then the person who gets the complaint is like, well, what noise? When did it happen? Like, how am I supposed to know how to respond to this? So legally, it's like giving them a chance to tell their side of the story. And then when the council has both sides of the story, then they have information to base a decision on. If everything is so vague, then it's not helpful, and your letter has then become ineffective. Weeks have gone by in the process, and the noise is maybe still happening and driving you crazy. So you've just wasted that entire chunk of time by not writing an effective letter and putting yourself in a position where you're probably going to have to write another letter, to try to be more effective. And so the problem here is that most of the time this comes as one sentence emails over and over, and it's not really enough to satisfy what the Strata Property Act requires, and it makes it really hard for your council to help you through that situation, because legally they need more.
Yeah.
Yeah. So anyway, and specifying like which rule was it? It's rule number 4 that you can't leave your towels in the pool area, or bylaw number 3 that says you can't cause unreasonable noise, or like you have to be specific, because again, when the strata makes a decision about whether a bylaw has been breached, you have to say what bylaw.
Exactly.
Yeah.
Yeah. Yeah, this is very similar to residential tenancies. When a residential tenant, when a landlord is addressing an issue with a tenant, it's really the same thing. We have a what we call at LandlordBC a caution notice. It's also, people call it breach notices, warning letter, that sort of thing. And it needs to identify what the issue is, how to resolve it, when to resolve it by. And the what the issue is part is just as you said, you have to identify specifically what the issue is. So what occurred, but also if it's a specific rule that's been broken, where's that rule? And so, yeah, I think there's a lot of common trends there for sure. How should that letter be sent? How can it be delivered?
Strata Property Act is a little bit different than the Residential Tenancy Act. So
Yeah.
for example, we can't put it on the outside of the door. That's not a legal method. But in the Strata Property Act, there's a great long list of all the methods that are allowed. And the most common ones would be to hand it to the person, not leave it somewhere, but just hand it to the person, mail it. You are allowed to send it by email, but only if the tenant or the owner has expressly said, I give permission to send official letters and notices by email. As you know, that's the same as you.
Yeah.
So what we find, it's best is a method that you can prove, right? So if you're going to deliver it in person to somebody, maybe you bring a witness with you, or if you're going to mail it, you take a picture of the letter just before it goes in the mail, or something, because you may need proof later that you actually delivered these. But the other thing about the delivery, if the violation is by a tenant, or alleged violation is by a tenant, the Strata Property Act says it's not enough to send that notice of complaint to the tenant. You also have to give a copy of the letter to the landlord. So you're not inviting the landlord to participate in defense, but you must notify them. And if we skip that step in the strata property world, then everything that happens afterwards is nullified. You have to do
Okay.
every step perfectly, and the Supreme Court has repeated this over and over and over. So it's very important to follow what we call Section 135 to the letter, if you want to be effective in this process. And then I think you're about to ask me the big the big question of
Well, who else can see this?
can see it. Yeah, so under the Strata Property Act, any communication between council and a tenant, an owner, a manager, those are all documents of the Strata Corporation. It's all correspondence. And under the act, any owner can request to see any piece of correspondence or get a copy of it. So that causes a lot of tension between, owner to owner and tenant and owner, is that someone can actually request to see the original letter of complaint. So when people are writing complaints, I always encourage them, like, don't write it in the heat of the moment and send it. Have somebody read it. Is it polite? Is it factual? Like, imagine that this is being published in the newspaper. Would you be embarrassed? Or would it give too much personal information? Dial it back, keep it really professional, just stick to the facts. And then the other thing is that there's a little bit of an imbalance here for the tenants. The tenants don't have that same right to request a copy of the letter unless their landlord has given them that express power and duty. So usually what happens is it's easier for the landlord to request a copy of the letter and just give it to their tenant. But
Yeah.
it's important for all the players in this to understand that pretty much, anybody who lives in the building could see that letter, and they're legally, the council would be legally required to provide it if it's properly requested.
Yeah. Yeah. And I think the importance there is the professionalism in those types of communications. It's the same with residential tenancies. Um, you know, would you like your mother to read that letter? What would she say about what you've written?
She'd say, I
um,
raised you better than that.
exactly. Um, so, but that isn't a really important thing. And with issues like this, it's very easy for um our personal experience, our emotions to really kind of get the better of us. So yeah, it's always stick to the facts very, very, very pointedly. And sometimes those can sting more than harsh words. So um so um we've talked about making a complaint, how does how to serve it, what it contains. What is the action that comes from that?
Yeah, and I started to talk about it earlier, but I'll just
Yeah.
briefly go again. So if the council receives a letter of complaint, the first thing they're going to do is say, well, is this about a bylaw? Or is this just a complaint about something else? If it's actually regarding a bylaw or a rule, then they have a duty to deal with it. And depending on what the complaint is, sometimes the first step is some sort of investigation. Um, it can be, limited at this point because you're starting the process. But then if they think, yes, this really is about a bylaw rule, we're not going to pre-decide that anybody broke it, but we're going to send a notice of complaint to let that other person know, here's what someone said happened, and here's the bylaw that they say was allegedly broken. And then that person that received that letter gets a period of time, usually about 2 weeks. There's no mandated time frame, but the act says you have to give them a reasonable amount of time to respond.
Mhm.
And so that person could either respond in writing to the council, or they could request what we call a hearing, which is not a scary thing. The word hearing makes tenants afraid, it makes owners afraid. It's not that scary word. It is just a chance to speak in person to council. So it's an opportunity if you wanted to write a letter and you wanted to go to a council meeting and have a chance to speak your case. Great, you can do that, and council can't say no. And they have to have that hearing within 4 weeks. But most of the time, people don't ask for hearings. They just send in a written response. And then at the next council meeting, council will look at the original complaint. They'll look at the response, if any, because lots of times, especially with tenants, they don't respond, and they should. And council just has to look at the information in front of them. You know, what is the complaint? What is the response? Do we think that a bylaw rule was reasonable? Like, is it reasonable to think that a bylaw rule was broken here? And if we do think so, what do we want to do about it? We could write a warning letter, but you don't have to write a warning letter at this point. You can make a decision to levy a fine. And that fine is whatever the bylaws say. So if they're using the standard bylaws, that can be, a fine can be up to $10 for breaking a rule and up to $50 for a bylaw. But most stratas have amended those bylaws to increase them. So for example, you know, you might have up to $200 for breaking a bylaw, but the council has to make that decision. And then there's a really important step after that. You can't just levy the fine. You have to send a decision letter to the person who's being fined to say, we've made this decision that you broke bylaw number. We've decided to levy this fine in this amount, payable by this date. And you have to give them a chance to have received that letter before you post it to the account. And that's a really important step. And a lot of times stratas make the mistake of posting that fine right away. And you have to give time for that. And you know this term, deemed delivery. So usually we say allow at least 4 days for that letter to arrive or that email to go through, or whatever the official method you're using. But then again, if the tenant is being fined, a copy of the letter has to go to the landlord. So again, there's the common mistake that's made is they'll send the fine letter to the tenant, forget to send it to the landlord, or make the mistake of sending a fine letter fining the landlord. The landlord didn't break the rule or bylaw, the tenant did. So you're not fining the landlord, you're fining the tenant. And that is a really common mistake. And if that happens, then you've broken the whole process. And you got to start again.
So that kind of that's important. So that the fine, when a tenant does something in a strata unit that results in a fine, that fine is against the tenant. So it's safe to say that the tenant is responsible for paying that, correct?
Yeah.
What happens though if the tenant doesn't pay it?
If they don't, yeah. So the Strata Property Act contemplates that situation, and it's very, very common because a tenant will get a fine, and generally they're just confused. You know, you got to give it to the tenant. They're not a strata owner. They've never probably read the Strata Property Act. So quite often, like anything, like an overdue bill or anything, it gets ignored. You know, people just go, oh, I can't deal with it, and they don't deal with it. So eventually the landlord is ultimately responsible for paying the fine, even though the fine wasn't against them. So that's where some of the confusion comes in. And there is a part of the act, I think it's section 112, that is basically, it's called written demand. And you send council sends a formal letter demanding payment for something. And that's a good formal step when a landlord, when enough time has gone by that the tenant hasn't paid it, and you're finally saying, hey, landlord, we're now saying that, you know, we have to collect this money. We want to collect this money from you, and here's how much you is owed, and here's the deadline to pay. And if you don't pay, you know, we could go to the civil resolution tribunal to make you pay. Things like that. So it's a very clear communication to the landlord that time to pay, and there's consequences if you don't pay.
Yeah, that makes perfect sense. And with that, if the tenant, you know, doesn't pay, then goes to the landlord, as we said, are there any provisions in the Strata Property Act that contemplates what happens with that landlord, the owner, and to collect from the tenant?
Yes, the Strata Property Act expressly says that if the landlord pays the fine on behalf of the tenant, that the landlord has the right to collect that money from the tenant. And I think that is a nice parallel with Residential Tenancy Act, right?
It most certainly is. Yeah, this is certainly something that is echoed by the Residential Tenancy Act in multiple sections. While it doesn't identify that specific item, the Act, when I say the Act, the Residential Tenancy Act, is very good at providing certain kind of blanket statements. So it talks about if there's breaches that result in a loss, which is exactly what this would be. Um, so great. And again, like I said, the collection of this would generally be through the residential tenancy branch, through their collections process, which is dispute resolution.
Yeah.
Yeah.
So that brings us to the next step, the obvious step. There's been fines, a problem is here. Under the Residential Tenancy Act, can a landlord evict a tenant for breaking these strata bylaws or rules?
Yeah, that's a really good question. The answer to that is yes. And they can likely under multiple different sections of the Residential Tenancy Act or points under the notice to end tenancy. We'd be looking likely at the 1 month notice to end tenancy, to end a tenancy for a breach of a strata bylaw. And as part of a residential tenancy agreement, there is an agreement to follow all those strata bylaws. So it's a term of the tenancy right there. And in addition, generally we're signing Form K, which kind of further cements that. It's not necessary under the Residential Tenancy Act. I know it's necessary for you for stratas to have those signed. But under the Residential Tenancy Act, whether that's signed or not is less important. It certainly is helpful. The agreement is still clear that those bylaws need to be followed. In addition, whenever anything like this is breached, it likely is also breaching other aspects of the act, disrupting the quiet enjoyment of other occupants of the building, putting the landlord's property at risk, possibly putting the landlord's lawful right in jeopardy, which certainly if the landlord has to start paying fines, that would be triggered. So there's a lot of different ways in which a tenancy might be justified to come to an end under the Residential Tenancy Act. And that process is actually very similar to what we've just talked about, issuing a fine, which starts with issuing some type of warning to the tenant saying, hey, this is something that I've been made aware of is happening. This is the issue. So here's what exactly what has occurred, what rule it's breaking, if it's a specific rule, or if it's more just a precept of the act in general, such as quiet enjoyment. Um, and then how to resolve the issue, which is generally, resolve it within, which is, generally stop that specific action, and then when to resolve it by. Depending on the issue, that might be immediate, such as noise issues. You can say, hey, don't have another loud party. But for other issues, you might have to give them some time to resolve the issue. And then what's going to happen if they don't comply? A really big part of the Residential Tenancy Act is ensuring that the tenant is informed as to what the outcome is going to be if they don't comply. So, simply stating that if you do not comply with this, your tenancy may come to an end. So, yeah, that process is fairly well documented and set up in the Residential Tenancy Act. And of course, there's forms for that on the Residential Tenancy Branch website.
Yeah, there's a lot of forms and letters in these processes.
There is. And sometimes that's good. It means that we don't have to, make up our own processes and forms. But yeah, it's really important that you're always using the most up-to-date and correct form as well. So always going to the RTB website to get those forms, especially for the notice to end tenancy. So we know that a landlord can end a tenancy. And I think we've covered that today as well as in other webinars. Can a strata end a tenancy?
Yeah, so very parallel to what you were just saying about quiet enjoyment and whatnot. There is a section of the Strata Property Act in section 138. I'm going to read it because it just says exactly what you're saying, but in our language. It says that the strata can evict when there's been a repeated and continuing contravention of a reasonable and significant bylaw or rule by a tenant that seriously interferes with another person's use and enjoyment of a strata lot or the common property. And that what it does is it allows the strata corporation to do exactly what you said, give a 1-month notice to end tenancy. So it's not that the strata corporation can take over all the rights of the landlord, not at all. All it does is it gives the right to the strata to give that notice to end tenancy. But what's interesting here is, it has to be repeated. It can't be one instance of breaking a bylaw, and it has to be a significant bylaw. So one of the examples I give is, if the tenant has purple curtains and the bylaw says you can only have white curtains, that is not a significant, in my view, it's not a significant bylaw that should result in eviction of a tenant. It's got to be reasonable. So a significant bylaw would usually be something like, the building does not allow smoking at all, and you've got someone smoking in their unit, and it is seriously interfering with another person's use and enjoyment of their strata lot or the common property. I mean, those are the examples we're talking about. But this is all fairly new, even though this piece of legislation has been here for a really long time. The residential tenancy branch only started recognizing this in November 2022. So we're only just starting to see decisions come through the RTB that have to do with a strata starting the eviction process. And of course, it's a process, as you know, so it takes time. So we did have an article in our most recent bulletin, our VISOA bulletin that came out in February, where a lawyer explained the steps that if a strata corporation wanted to evict, or at least try to evict, here's the steps that they would take. So I won't go into all of that, but it all starts with what you said of delivering that 1-month notice to end tenancy.
So yeah, as you say, this is fairly new from a residential tenancy act point of view, at least.
So from the Strata Property Act point of view.
Well, yeah, I mean, no, the
Or,
ending tenancy from a strata's point of view. I mean, they only, as you say, they only just started recognizing that, and really, only created the form, a year or so ago. So it's not, it's not something that we see a lot of. Certainly, anyone in that sort of situation, should seek legal advice. As you said. And my understanding too is that, a big part of this is it gives the strata recourse really when the landlord, the owner, is essentially not doing their job.
oh, you're right. The Strata Corporation does not want to have to go through this process.
Yeah.
Honestly, it's a lot of work, it's a lot of pressure. And why should we have, as council members, have to know the Residential Tenancy Act? We already have to know enough legislation. We're never going to be experts at every piece of legislation. So really, I think one of the reasons, one of the things about the strata being able to evict is it's another way of informing a tenant that there's consequences and just trying to change the behavior. This is a last resort. I don't think councils out there are rushing to want to go through a process to evict. It's not. I think it's a step of last resort that's there if needed. But hopefully, if a situation is bad enough that an eviction is a reasonable step, hopefully it's the landlord that's doing it, and not the council. But if the landlord is also aware that the strata corporation has the right to do this, it might sort of push the landlord to try to handle the situation themselves. And so I think, I don't want tenants to be afraid of this process, but as long as they're aware and it helps them change their behavior, great. That's the point of this, is fix the behavior so everybody can live their lives.
Yeah. So yeah, that makes perfect sense.
Did we forget anything?
I think that we're just near the end here on conflict reduction.
Oh,
Um,
I
yeah,
like what you said earlier, like deal with things early.
yeah,
Yeah.
yeah. I think that that when it comes to reducing conflict, I think that we really focus on these kind of nightmare situations that we see and hear about in the media.
Yeah.
Um, and I'm not gonna you know say anything negative about the news media, but they're there to generally highlight. They generally are highlighting outlier type situations. And I think it's really easy for anyone, landlords, tenants, stratas, um, to look at those and say, oh, well, I have the exact same situation because my tenant had a loud party on a weekend, so they're probably a nightmare tenant. They're probably not a nightmare tenant. The majority of tenancies go off with very little issues. Um, and in any relationship, conflict can come up, but it can be resolved. If we didn't have any type of conflict resolution, it'd be a much scarier world. Um, and I think, most of the conflict that occurs comes down to a lack of knowledge, a lack of
Yes.
understanding, which I think are two very different things, um, and uh, yeah, just perhaps also lack of awareness. So a big part is from landlords making sure that tenants are aware of what of the bylaws that are in place. Um, Specifically those ones that are going to really have an impact on their day-to-day, as well as the clauses in their residential tenancy agreement. I think it's really easy in our current age to just sign a contract um, and not really review anything. I know, I mean, I'm sure I'm guilty of it. I don't think I've ever read my cell phone contract anytime I've entered into one. Um, um, but with residential tenancies, it's really, really important that both landlords and tenants fully understand what they're getting into in that agreement. And part of that is the tenancy agreement, and part of it is the bylaws. And then to communicate early, often, politely, with compassion. Um, you know, those are important things. Everyone's got stuff going on in their lives, so it's important to always kind of address things in how would you like to be addressed on an issue, um, and it's about informing them that, hey, this wasn't a good thing that happened. This, you caused this disruption. Uh, we want to make sure this doesn't happen again. We want to make sure you're aware. Do you have any questions? Um, so it's really important to not escalate things as well. And I think that's another important part of this. We've talked a lot about writing letters and giving notice, and those are very important aspects. But we need to gauge the situation. How serious was it? And can we just have that conversation to start with? Is that maybe the first step, as opposed to just jumping right to a notice?
Yeah. Um, is it time to go to questions?
Yeah, I think
Yeah.
that we have some questions that have come through for sure. Um, so this actually has to do with the record keeping, I suppose. Is there a requirement by council to inform or document and make available who the complaint was made by to the person who the complaint is against?
Yeah, in that notice of complaint that lets the person know that a complaint has been made or that there's an issue, you don't have to include the name of the complainee in the letter. However, like I said, any owner or person who has the right under the act to request a copy of correspondence could make a request to see the original letter and get a copy of it. So, so although it's not disclosed, or I don't recommend disclosing it in the original notice of complaint, just be aware that there are ways to find out who complained.
And I think that, the other part to this is where that people should be aware is that, while we've just talked about trying to resolve complaints early and everything, we also have to be aware that the exact opposite could happen. We could end up in having to end a tenancy in dispute resolution, in which case things like witness statements um, and such, or even having witnesses be present at hearings, is going to be very necessary to move forward. So while that initial process might, you know, have a certain amount of anonymity to the person making the complaint, that won't necessarily be there the whole process. Especially with the resident or tenancy and their dispute resolution process, they really want to know who's made that complaint, why are they qualified to make that complaint. Um, So, question here is around what is considered reasonable noise. So we have this concept. It's in the Residential Tenancy Act, kind of doesn't really talk about this, but it we mentioned in our agreement about a kind of quiet time in a building, and I know a lot of stratas are likely going to have something like that in place. But we make noise all the time anyway. During that quiet time, what would we consider reasonable noise? How do we
The
assess that?
courts, yeah, the courts have decided what reasonable is, but it's usually on a case by case basis. But the whole concept of nuisance, which noise is a nuisance, is what would, and here I won't have the words right, but the court has said, what would a reasonable person be able to bear,
Yeah.
basically. So, while some people might be more sensitive to noise and they can't, it really bugs them that they can hear their neighbors talking from time to time, that may not meet the bar of a reasonable interference, because it's more about it's not just that you hear noise, it's got to be repeated or continuing
Mhm.
or something. So once in a while, if somebody drops the remote to the TV or their keys, that is not a repeated, and you should expect living noise. But if somebody's playing video games on their TV for 8 hours at a really high volume, and it's the neighbors can hear it, that's perhaps a situation that would be more serious. But there's also a great quote from the court that I think is really helpful. Particularly, we get a lot of complaints in wood frame buildings, and there is going to be noise. We have to expect that. But what the judge said was, living in a strata building involves some degree of give and take among neighbors when it comes to noise and other potential nuisances. And so we can't expect the kind of quiet that we might get in a single family home. And that's really, really hard because, as you said, everybody's idea of what is reasonable is going to be different. And that's why the case by case is really important.
Yeah, the Residential Tenancy Act loves the word reasonable. Um, and uh as much as I completely understand that, it does make, interpreting these sorts of issues not overly simple. So yeah, it's how repeated, how impactful is that noise on
Mhm.
on a reasonable person. Um, Let's see if we can find a reasonable person.
Yeah, which is why it's great to keep a noise log. Because,
Yeah,
duration is important too. If the dog barks 3 barks, that's one thing. If a dog barks for 15 minutes straight and is doing that 3 times a day, every day, there's a very, very big difference.
yeah.
So having noise logs is important because time of day, what type of noise and what the duration was helps illustrate when there really is a serious problem, as opposed to just these occasional noises.
Mhm. Uh, okay. Um, a question around minutes. Um, should council distribute minutes directly to tenants, or should it be the decision of the landlord whether they pass them on to the tenant or not?
The tenants have no right under the Strata Property Act to receive any documents unless the landlord has given them what we call assignment of powers and duties, which is basically the landlord saying, I no longer want my rights
Mm.
for certain things under the Strata Property Act. I'm giving them to my tenants. And that doesn't happen often because it's a pretty serious thing. It means that the tenant can be a council member. The tenant can vote at the annual general meeting. So, a landlord wants to be pretty careful before they give those types of powers and duties to their tenant. However, there's nothing, the landlord can ask for any of the documents that are allowed to be given to an owner and pass them on to anybody they want. So yes, if the landlord requested, or if the landlord decided to give copies of minutes to their tenant, that's up to them. But the Strata Council is not required to inform tenants that the minutes are available, and they're not required to give a copy to the tenants. Now, some stratas put a copy of the minutes, say, in the laundry room or the library or some kind of common room. If the tenant wants to read them, they're publicly posted, that's fine. But every strata is different in how they notify their owners that minutes are available to read.
Certainly. Um, so, it's not uncommon for landlords who have a rental unit in a strata property to maybe not even be in the same city, or perhaps maybe be away on extended vacation, for example, a month or two in Mexico. How should council respond to a landlord who requests to not be involved with the matters, tenant matters specifically, while they're away on extended vacation?
Interesting. There are some things under the Act, under the Strata Property Act, I should say, where tenants, where the strata is responsible for notifying tenants. I'd have to look at the list, but things like the annual inspection of smoke alarms, or the boiler is going to be off for a day and there'll be no heat. Those types of notifications, I'd have to check to see which ones are actually required by the Strata Property Act, but there's certainly ones that you can give directly to the tenant. There's nothing that says you can't.
Mhm.
It would be more of the official records of the strata where you have to be a little bit more careful
Mhm.
what you give and what you don't. The tenants also have certain rights, like if they write that letter to request a hearing, the strata has to respond to them with a decision of the hearing, and that decision
Mhm.
letter goes to them. So there are certain communications that definitely go to a tenant. Did I get off topic? Did I
Well,
answer that question?
I think you didn't. I think I can add something to this. I mean, uh, there is, as you said, I mean, already about Stratus being able to um, uh, issue fines against tenants, to end a tenancy, if the owner isn't going to be involved. I would say to any owner though that when you choose to rent out your rental unit, you are entering into a business. You're now running a business. Um, and it's a business that is uh, governed primarily by the Residential Tenancy Act, but there are many other pieces of legislation that have an impact, which is why we have this webinar series. The Strata Property
Right.
Act, it has a significant impact. There's other many other pieces of legislation. I could probably spend, an hour-long webinar just listing different pieces of legislation that'll have an impact. But the point is that you have a job as a landlord. And ideally, you set everything up so that things go really well and you don't have to work a lot of it. But from time to time, there is work that's involved. And it's important that you take action on that, because if you don't take action on it, this council might take action, which might mean fines getting levied, which ultimately come back to you if the tenant doesn't pay. It might mean ending of tenancies, which means that you're now going to have to step in and try to find someone to replace that tenant. Um, and it's much more of a hassle to try to get yourself out of that situation and resolve it after the fact. As than just simply doing the work up front. And a big part of that work is your tenant selection process, making sure that you get the right tenant in there, and then setting up those types of avenues for communication early on.
Well, I bet it must be a big hit financially for a landlord to go through a process to end a tenancy in some cases. So, I mean, why wouldn't you just want to deal with your tenant and run that successfully so that your tenancy is successful for you financially? It just seems like a win-win for the landlord to be paying attention to what's going on in the strata and what's going on with their tenancy.
Mm-hmm.
Yeah.
But I mean, it is important that if you're running a business, that you're active in it. It's a big investment. So you don't really want to leave things to other parties when you can be involved. I think we have time maybe for one more question. Let's take a look here.
There's a lot of questions about enforcing bylaws, so people can contact me afterwards.
Certainly.
I'll put the because we don't have the chat open.
Yeah.
It's just
we'll be sending out a follow-up email, so
we can send a follow-up email with contact information. Okay.
Exactly.
Sounds good.
Just really, one question. What does a renter and strata do if the bylaw violation is caused by a landlord's action or inaction? I assume what this is in a situation where perhaps maybe there's something that needs to be done in the unit, that the owner was supposed to do, and by not doing it, it is now breaching a bylaw. The tenant's kind of stuck in the middle. Perhaps maybe it's impacting them as well. Maybe a state of repair issue, for example. In those types of situations, I mean, certainly I think, council's going to have clear, pathways, including issuing fines to the owner and such. But does the Residential Tenancy Act offer any type of conflict resolution so that it's not just council having to go to the CRT? So I think maybe what I'll do is I'll just apply a situation. We'll say it's a state of repair issue. It's affecting both the building in general some way and maybe breaching a bylaw, but also affecting the tenant's ability to live in the unit as they should. And the Residential Tenancy Act has a dispute resolution process, and it allows tenants to apply against landlords to ensure that things like repairs are done timely and in general. And that can come in two forms. One, as an order directly from the residential tenancy branch saying, do this. So the landlord has to do this, as well as a monetary award to the tenant as well. So if the state of repair has caused a loss of value and maybe a loss of use, if they can show that loss, they can make a financial claim as well. So there is certainly grounds, and it's up to the tenant to take their landlord to dispute resolution, which is again, I think, highlighting why, as a landlord, you want to make sure that you're present and aware of what's going on in the building and in the unit. So, I think that brings us to the end of our webinar today. I want to thank everyone for your attention and for your questions throughout today's webinar. It's great to see so many people here today on a Saturday morning. Um, uh, but really happy that we were able to get this information out. I think that if we were to recap all of this, my takeaway is there are some very well documented, maybe straightforward, perhaps is maybe the way to say, processes and forms that can be used, but really the solution is communication.
Absolutely. And if I can just take a moment, Hunter, thank you so much for hosting this entire series of 4 webinars. And I really hope that that our viewers today will check out your YouTube channel, LandlordBC, and also VISOA, which is just VISOA videos, and just come back to these at any time and use them as resources. It's been just a great process to try to educate both landlords and strata owners and strata councils, because if we're all educated on some of these things, then we can hopefully reduce issues.
Yeah, well, and thank you so much, Wendy, for sharing all of your most vital knowledge. It's great that we're able to enrich experience of both landlords and strata councils through this series. Thank you again to everyone who is here on this webinar. And as Wendy mentioned, go to our YouTube channels to view our past videos in this series and many other. I know that I've gone to the VISOA YouTube channel many times to look up things, and there's a lot of very useful information there. Thank you. Have a good day, everyone.